right, let's get situated here. All right, it is exactly 9 a.m. Let's bring in Hannah and Bailey.
Yes.
We'll bring in Mr. McCann as well. Good morning. This is Judge Middleton. I'm here at the courthouse in Centerville. We've got several landlord-tenant matters scheduled for this morning. We have one set for 9 a.m., which is our first case. It's entitled Kurt Allwine versus Hannah Green and Bailey Cunningham and any others. File number is 21349LT. Mr. Allwine, where you are, right there at Mr. Gibson's office, and Mr. Cunningham and Miss Green, I can't see you, but I want you all to raise your right hand. Wherever you are, you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
I swear.
Yes.
All right, they all affirm that. This was a possession judgment for a property in White Pigeon. The possession judgment entered in April and the defendants have vacated. I told you at that time if there was going to be an argument about money damages, we would have a hearing. So the plaintiff has requested money damages in a formal complaint. They're asking for $500 for the driveway, water damage from flooding from the shower, $1,605, damage to an adjacent building, $144, unpaid rent of $1,260, and $900 the opportunity of lost rent. So they're asking for $4,409. Let's see if we can take the easy question first. Mr. Allwine or Mr. Cunningham and Ms. Green, do you agree that the rent was $1,260 delinquent?
On that?
Yes.
We have both of the months of rent. We just held them because of all the court and everything that's been going on. Figured we wouldn't pay rent until we got told what was going on. And
all right, well that I don't disagree with that. So you acknowledge you owed 2 months of rent?
Yes.
All right. And was there a security deposit?
Yes, it was
Yes.
$900.
That's not calculated in here.
Yeah, we never received our security deposit back.
No,
All right.
sir.
Now, how much was rent each month?
$900. We didn't pay rent for the month of March, and then you gave us April 15th, I believe, was the about, and we were moved out by April 15th.
All right, we'll discuss that further. Now, the tenants moved out on or about April 13th, did not pay monthly rent for the March for the 12 days of April. So that's where they came up with that 900 March, 360. So we're in agreement with that rent figure. Now they're asking for $900 for an additional month. And the landlord didn't re-rent the property until May 12th. I don't have the whole file here, so I'm gonna have to look at that. There's Bettina from Keystone.
Good morning.
Good morning. Bettina, we're in a damage hearing. Might find this interesting. All right, let's talk about the water damage. We'll leave that on $900 for 1 month rent up in the air. Mr. Gibson contends that shower flooding costs $1,605, and there was a attachment B, which isn't attached here. Yeah, oh boy. What do you guys say about the flood damage from the shower?
The flood damage in the shower where we were resigning at, Kurtz, it has a removable shower head to where you can take it on and off. So when you put it on and off, it adds tension on the shower and pulls it up and down. You know what I mean? And because Kurt told us he'd put the shower and all that stuff in there. So when he put the shower head to the plumbing in the wall, instead of using like a brass fitting, he used a plastic fitting. So of course, over time it busted, and we didn't realize it. So once the water's going, I seen it on the floor. I messaged him. He came over about it. We did the things we needed to do about it. We agreed that I would pay for material costs and help him, and then that would be that. And then one day he come over saying that I owed him, that we were going to have to pay him all this money to do it. And I was like, no, this is not necessarily our fault. This is all we were doing was using the shower. So it's not like we were both in the shower. Shower was too small for both of us to be in the shower. So I like to shower alone in there. So it was just merely from us using the shower, and it busted. We contacted him. He came in, drained the water, put his stick up, told us that all he had to do was mud it and flow it all, and it'd be fine. It took him 3 or 4 months. I don't have the paperwork here on how long it took for him to actually come in to want to assess the work and actually do it. So over time, the ceiling got even worse than what it was beforehand.
Was there a tub in the apartment or just the shower?
It's a shower tub.
Okay.
It has tile walling in it.
All right. Well, what he's got here, 70 hours of personal time. That's 2 35-hour weeks at $15 an hour. 24 hours spent by contract labor, $360. So he's got 105 hours of labor, 2.5 weeks to fix this, then material. Mr. Allwine, how did you come up with that figure?
Just kept track of my time, and then the material is very simple as far as what I bought and what I had to use.
Well, who is your contract labor?
Me.
So you got 70 hours at $15 an hour plus $15 an hour for You got 105 hours to fix this shower?
You want to explain it, Paul?
What was there any other people that helped you, Kurt?
Yes.
So I believe some of the labor is for himself, and then some is for his employees that work. He has other people that work for him, and so he had them work on this as opposed to doing the other things they would normally work on for him that are
Well,
unrelated to this.
what did you actually do, Mr. Allwine?
Pulled down 2.5 sheets of drywall from the ceiling, replaced them, mudded them in, repainted. And I also had to jack the basement floor up a bit because the water had made it sag.
Now,
Well,
he had gotten some estimates before he decided to do the work himself. He had gotten 2 estimates from contractors, and they were far more expensive. And so he felt that he could save, obviously, the defendant's money if he did the work himself, because it was going to be around $6,000 to have a professional do it.
all right. They indicated that he waited several months after he was put on notice before he came to fix it. What can you tell us
because
about?
it happened in October, because we moved in at the end of September, and it happened 2 weeks after we moved in. And he didn't come to look at the ceiling. He came the night it happened and put the stick up, and he didn't come back again until maybe February or March.
Mr. Allwine, what was your understanding of how the shower got broken and how the water leak occurred?
He had a basket hanging from it with all their soaps and stuff, and then it weighed too much and it broke it off with inside the wall.
Well, is it true you didn't address it until months later?
I fixed the shower head immediately, but then the whole basement, the day that happened, I went down there with a 5-gallon bucket, poked a hole in the sagging ceiling, filled up the buckets, dumped them out. Then it has to dry a bit before I can actually work on it. And then I have repeatedly, which I can prove with text, tried to make time or get with Bailey or Hannah to see when I could do this repair. And it was quite obvious to me they did not want me to do the repair because they're afraid of how much it would cost. So it just drug on forever, and eventually I just had to put my foot down, and this is it.
Okay. All right, let's talk about the damages to the driveway. $500 for the driveway. What can you tell me about that, Mr.
Mr. Allwine, prior to the defendants moving in, can you explain to the court what you had done to the driveway?
Top coat asphalt sealers out of Sturgis, reseal coated my entire parking lot 3 days before they moved in.
And what was the date of that?
The date on that is 9/17/20.
So what is that all that they did, top coat?
Then do all my lines and handicap marks, and
So how much did that bill run you?
$1,725.
And then what type of damages did the defendants do to the driveway?
Multiple burnouts right across the lines and out in the middle of the parking lot, even right up next to my door. Oil stains from their leaking vehicles and doing maintenance on vehicles.
Did you ever see them trying to repair a vehicle while in your driveway?
Absolutely.
Is that permitted?
No. You want to show him?
So you've got, I've got some exhibits here.
All right, well, I see that there's an estimate.
I mean, I have photos that I could submit to the court. I mean, I don't know what, in a situation like this, it's hard to,
Well, you do a screen share, but you're holding it up to the screen. I can see the the
I could
burnouts.
probably,
Just let me stop you for a minute, Paul. John, do you have to be back on the criminal side?
At 9:30, Judge.
Okay, your defendant isn't here. I'm gonna let the clock tick for a couple minutes on this. You're here on Folsom, and we'll do that. It sounds like it's gonna be a default. So let me go a little bit farther with this, and then we'll address yours.
Thank you, Judge.
All right. Now, we've got $144 worth of damage to the adjacent building. What can you tell me about that?
Okay,
The-
Hannah, she was backing up and she slid on some ice and she backed up into the corner of Mr. Allwine's building. And they went through insurance companies and everything. Her insurance company actually wrote him a check. So that's why I was kind of curious on why this was even partook in any of the court matter when he was writing a check from her insurance company and all that was resolved that way.
And whether he cashed the check or not, that was on him. Like, he had so many days to cash the check on what they
All right,
estimated.
so
the
just a
damage would
minute.
be.
Your auto insurance paid him for that damage?
Yes.
Yes,
All right.
sir.
Mr. Allwine, what do you say about that?
That is not true. Actually, her insurance was supposed to mail me a form to fill out regarding this. And they mailed it to Bailey and Hannah. I never received it. They called me to ask me if I had received it, and I said, no, I didn't, and they would mail it out again. And then again, they mailed it to Bailey and Hannah. So I never got the form to fill this out.
I never received any information like that from my insurance company. The only thing I received from my insurance company was documentation on my part on my vehicle about the damages that it was costed to my vehicle.
I have never received a check.
All right. Was there, so Hannah, you don't know whether he actually got a check. He says he did not. So you assumed that
My
that had happened.
insurance company, I spoke to my insurance company and they said that they issued a check and that after the check is been to the mail that there's so many days, I think it's 30 days after they send it out, if you don't cash it, then the check, I don't remember the wording he used, but that was all on Mr. Allwine, but my insurance company did say they sent him a check.
Who is that person?
I'm not sure. I go through acceptance insurance in Indiana.
Well, he says he didn't get anything and he put it in here, which sounds plausible. I was thinking perhaps there was some deductible or something.
Because I received a check for my damages on my vehicle to pay for those damages. So.
I did not.
All right. Mr. Allwine, do you agree
Yes.
that there was a $900 security deposit,
Yes,
which was not returned?
no.
All right, we're gonna pause this for just a moment while I free up Mr. Bush and Mr. Affolter. Mr. Bush's got to be two places at once. These Friday mornings are very busy, so we'll suspend the record for a minute in Allwine. And we're gonna pick up 21812LT, which is entitled Karen and Brian Affolter versus Jennifer and Joshua Folsom. This is a termination of tenancy matter that was served by attachment. John, since it was served by attachment, I can't do a default and I have to reset it for 7 days. The Folsoms are not here. If they were personally served, I could simply do a default.
I had shared that with my client that what was likely to happen today.
Are they still there?
Yes. They're not doing a very good job. They brought the property to the attention of the city for garbage and rubbish and broken windows.
Okay. No personal service. We have to continue for 7 days. Let's take a look, John, see how we look for next Friday.
Let me go check there too.
All right.
What do I have for next Friday?
Next Friday is the 25th.
Your Honor, next Friday, I think I have an eviction with you at 1:30 in the afternoon.
That doesn't sound right. The 25th, I don't show anything in the afternoon.
I'll check again. He says he doesn't have anything. Apparently it was on with a question mark. It might be dismissed. So
Okay. How about 10 o'clock in the morning?
I have an all morning hearing that day.
Oh, boy.
It starts at 9. I don't know.
Well, we could set this for, where's your hearing?
It's Zoom. It's
All right, let's set this for 8:30 on the 25th.
probate court. It's probate
How about
court.
if we set it for 8:30? We should be able to get you in and out of there in time for your probate hearing. I don't want to adjourn it any longer than 7 days. They want to get them out of there. For Friday, June 25th.
We'll be there.
All right. Mr. Affolter, the law requires I give 7 days notice if the defendants are here. If they're personally served, we can do a default, but they were not. So I have to adjourn this for 7 days. So we'll address it early in the morning next Friday morning, okay?
Okay.
All right,
Thank you,
Judge.
All right, John, I'll let you get back over on the criminal side. All right, now I've got another one here, Paul. Good morning, Mr. Soltis and Ms. Brewick. We're in the middle of a damage hearing, but I didn't want to hold up the others if we could get them on their way and we could then focus on our damage hearing. This is the time for the hearing in Judy Lines versus Julie Miller. File number is 21824LT. Mr. Robert Soltis is here on behalf of the plaintiff, Judy Lines. Her daughter, Kathy Brewick, is also present. Julie Muller is not present. This case was an earlier case where the time passed for the termination of tenancy. And I wrote Ms. Lyons and Ms. Brewick a letter saying, you're going to have to start over again if you're going to pursue an eviction. And so they have, with assistance of Mr. Soltis. So, Mr. Soltis, the defendant is not here. She was personally served. Ms. Brewick, is she still there? Your microphone's on mute.
Yes, Your Honor, she's still there.
Mr. Soltis, what's your proposal? We simply do a default?
Yes, Your Honor, this is a restitution, not restitution. This is for a 30-day termination of tenancy. And therefore, she doesn't appear here. We're asking for a default judgment. Date of eviction is June 28th, which I understand is a Monday. Same day for the right to appeal or motion for new trial. Then I can send an order down to the court this morning.
All right. The defendant is not here. She was personally served. It is a termination of tenancy action, and she is subject to default, as Mr. Soltis has indicated. Mr. Soltis, you can submit a judgment with those dates. What's going to happen is she's either going to log in about 10 minutes from now, or she'll call on Monday saying something, but she has 10 days to set it aside. All right. We'll grant default. Defendant failed to appear. And lines have been trying to get her out for several months. The problem is, as you know, Mr. Soltis and Ms. Brooke, you probably are aware of this, there's nowhere to go. These termination of tenancies at the expiration of the lease are the toughest cases I have. The landlord doesn't want them there anymore. They're not subject to the CDC COVID stay, which is about to expire on June 30th. The landlord wants their property back, and the tenant probably would move if they could find somewhere to move to. And from the letters this defendant sent, she was having trouble finding some place to move, but at least she could have showed up for her hearing that she was personally served with. Mr. Soltis will submit a judgment for possession 6/28 as date for the writ. It's now 6/26. The defendant isn't here, and I don't expect she's going to show up. All right, Mr. Soltis, if you send me that judgment, we'll sign it. And I don't know what she may do, but we'll cross that bridge when we get to it.
Very good, Your Honor. We'll see if that gets down to you this morning.
All right, thank you. And thank you, Mr. Gibson, for letting us let the other people jump ahead, like playing through on a golf round or something, but we got them out of our way so we can focus on our stuff.
Thanks, Judge. Thanks, Paul. And
No problem.
okay. Thank you.
All right, thank
Good
you.
night.
Ms. Lyons, I'm going to remove you, or Ms. Brewer as well. All right, we've got a couple things percolating, but I'll set that one aside. All right, let's go back to our damage hearing case. We've discussed rent. We've discussed the parking lot issue. We've discussed the shower issue. We have established there was a $900 security deposit that needs to be factored into this. We discussed building damage, and then the issue that the plaintiff had to another month before he was able to re-rent the property, which is actually pretty good. So, Mr. Allwine, you got a new tenant in there on May 12th, is that correct?
Yes.
Right in the middle of the month. All right, Mr. Cunningham or Miss Green, is there anything you want to tell me?
With the driveway, my concerns on the one in the front of the building on the line. I have really wide tires on my truck, so I lose a lot of friction on the ground. So when it's wet, if my truck's wheels are turned to when I'm turning, because I have to turn wide because they're wide wheels. They rub if I don't. My truck will slide, so I'm not initially burning out. My truck can't even honestly do a burnout. I'm ashamed to say that, but it can't. And the one in front of the building, that's all from the ice, Your Honor. He wouldn't allow us to pour salt on it, and I had to go and just break down and go get this salt that I found that was really expensive and made just for asphalt so that we could break down the 6 inches of ice that we had to walk on every single day in the winter time. We were falling out there and everything. There's times my trucks couldn't even get out because there was so much ice built up that my truck wouldn't move. And there was no way I couldn't not spin my tires to get it to move. You know what I mean? And that's where I feel like those came from. Because, like I said, unfortunately, my truck cannot do a burnout. I wish it could, but
Your Honor, Mr. Allwine would have. Can I have Mr. Allwine explain his side of that?
Well, he acknowledged that his truck did it. He just acknowledged he didn't do it intentionally. So, but it still did it. Miss Green, is there anything you want to tell me?
Not that I can think of. Just like, I mean, with what Bailey said, we were pulling in one day and his truck slid on ice because for the month of March and the little bit it did snow in April, with all of the eviction stuff going on, Kurt wasn't plowing our driveway. I mean, he shut the internet off on us. That was supposed to be included in our rent also. So when we pull in the driveway, we were sliding on ice. That explains how I backed into the building because the ice nothing was getting plowed.
Okay. Let me look at your lease. I don't have the whole file here. I only have it electronically, so I gotta scroll through this to find the lease. All right, let's take a look. Lessor shall furnish sewer, water, trash, Wi-Fi. How many months was the internet shut off?
It was shut off for the whole month of March and the 13 days we were there in April.
All right. I'm going to allow $10 for March and $15 or $5 for half of April. So that's the rent is $12.60 minus $15 is $12.45. Is there anything else you want to tell me? Ms. Green?
I don't have anything else to say. I'm not sure if Bailey does.
All right, I think he did. All right, here's my finding. The rent is not much disputed. It's $1,260 minus $15 for the internet that was not provided pursuant to the lease. So it's $1,245. There is a security deposit of $900, which should be applied to the rent. So that leaves $345 as the rent component. I am going to allow $900. Mr. Allwine did a good job of releasing the premises. Let's take a look at this lease again. It was a 1-year lease commencing 9/22/20, and it would have been up 9/22/21. Excuse me. I need some water. So it was during the period, and he is entitled to lost revenue. He didn't let any grass grow on it. In fact, rented it in the middle of the month. So I will allow that. Excuse me. This is very annoying for all the people listening to this. So I allow $900 for lost rent. I'm going to allow $1,000 for the water damage, $144 for the building damage, and $500 for the driveway. So let's add that up. 500 for the driveway, $345 in rent after we secure or remove the security deposit, $1,000 for the water damage, $144 for the building damage, and lost rent of $900. That's not right. 500 driveway.
Excuse me, Your Honor.
Just a minute.
Okay.
900 lost rent, $1,000 water damage, and 144 is $2,889 plus the costs, which are $75 for the first hearing for the attorney fee, $75 for the damage hearing. Darn it. Paul, let me look at this. I don't have the file I need, so if I can figure out the filing fee and the service fee. Do you have that information, Paul?
Oh, the service fee?
And the filing fee?
Yes. Let's see here.
I don't have the face sheet on here, which I probably should have done for myself. Yeah, it's hard to tell from looking at this what those fees are.
Okay, here it is. It looks like the service fee was
$76.12.
Oh, okay. I have a bill from Southwest Legal Services for $72.16 that was dated March 6,
Yes,
2021.
$72.16. And I can't tell from what I've got in front of me what the filing fee was.
I believe it was the, oh, that's true because of the, I should be able to find that.
Ms. Green, if you do discern that your insurance company did send him a check for that damage, I would reconsider the $144. So if you can present some showing that that was actually paid.
I don't have the document right in front of me right now because I'm at
Well,
work.
if you can get confirmation from your insurance company, I would reconsider that part, but that's my finding. Guadalupe, could you tell me what the filing fee was in this case? I don't have the face sheet on here, so I can't tell what it was. There's two defendants. It's in here somewhere. I just can't see it. what's your address? Are you guys still at the trailer park?
Yes.
All right, lot 105.
Yep.
All right, the damages, Paul, you can submit an order to this effect, are $2,889. I removed some of the damage. I removed a small amount for the lack of internet, and I applied the security deposit, which brings us to $2,889. The attorney fee is $150, $75 for the damage hearing, $75 for the principal hearing, $72.16. And if I knew what the filing fee was, we could complete this. Paul, have you found that yet?
Well, I know that we paid the basic filing fee for an eviction or for, I guess,
and then you paid for supplemental damages.
right.
So
And for supplemental damages, I think it was around $130, but I'm trying to find the cover letter that would have been sent with the original complaint. That would probably have it on there if I have it.
well, I usually have it on, here it is. 130 is, all right. All right, so the costs are $150, $130, $72.16 equals $352.16 for costs plus $2,889 equals $3,241.16. Mr. Cunningham, Miss Green, can you make any sort of monthly payment on that? Or do you simply want to just leave the judgment?
We can do a monthly, but I had a question. You had stated something that our year to year, and when we moved in, it was supposed to be month to month.
Well, it says on the lease, let me take a look.
Yeah, Kurt told us that it was month to month.
All right, well, let's take a look. Mr. Allwine, what's your response to that?
I didn't hear you, sorry.
Well, they said the lease was a month-to-month lease.
It was a year.
All right, the lease, it says that it is a private dwelling for a period of, in bold letters, 1 year, commencing on 9/22/20 and ending on, it's blank there, but it is a month-to-month lease for 1 year. So that it says it in bold letters, 1 year, which is what I ruled on. All right, how much can you pay each month?
I'm not sure right at the minute.
All right. We'll just leave it as a judgment. You have 21 days to pay it, and then they can pursue collection, which could include garnishment of wages or other things. But if you get a stimulus check or you win the lottery or you get a tax refund or something, you pay it off all at once. But Mr. Gibson is going to submit a judgment, which I will send to you, saying the damages are $2,889. Court costs are $352.16 for a total of $3,241.16. And then I guess you guys can pursue how to pay it. Mr. Gibson may subpoena you in for further discovery on the ability to pay. All right, I'm going to remove everybody from this hearing. Thank you for being here in a time.
If I could just ask of the defendants, I'm not sure if they're willing to tell me if, I mean, Mr. Allwine's concerned about getting to appreciate that.
All right. Hannah, are you employed?
Yes, I am.
Where do you work?
I work at Keystone.
RV?
Yep.
And Mr. Cunningham, where do you work?
Over at Bennington Marina. Take Weldon pontoons.
Those are nice pontoons. The Benningtons are top of the line. All right. We've got that information. You can contact Mr. Gibson regarding some sort of payment plan and get this thing over and done with. All right. I'm going to remove each of you and we'll go on with our other hearings. Thank you very much.
Thank you.
Thank you.
All right, Bailey. Paul. All right. Good morning. We started our day with a damage hearing. My preference would have been to stick it at the end rather than at the beginning, but we managed to get through much of it. So we're in pretty good shape. Thank you for waiting. Let's set that aside. We've got Mr. Larkins is here regarding Sydney Bratcher, and Mr. Bradshaw is here regarding Mr. McCann, and we got Brandon Crew. Brandon, which case are you here on?
Rent Center, and if possible.
Yeah, that's right. That's at 10, Brandon. I'll put you in the waiting room. You've been struggling with that one. All right, put in waiting room. All right, Mr. Bradshaw, let's do your case first.
Okay.
It's set for 9:35. Mr. McCann is present, and then we'll deal with Larkin's case. Bettina Emery is here from Keystone. Mr. McCann, can you hear me?
Yes, I can.
This matter is filed as a demand for non-payment of rent. And as such, you are entitled to be advised of your advice of rights. As a defendant in a landlord tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, or other action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case, that's Keystone Place, may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone or other agency. The summons and complaint from the court case are sufficient, and you've already received that. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. Bettina Emery is here from Keystone Place. She's our housing advocate. Have you been in contact with Keystone?
Yes, I have. They had contacted me just a couple days ago as well to have me send in proof of my unemployment with my name on it and my most current utility bill, in which I have sent it in, and then I also resent it in just this morning before getting on here.
Mr. Bradshaw, what's the current arrearage?
The amount to retain possession through the month of June, Your Honor, is $769.49. There's $13.66 in utility charges. The court costs are $172.80. So the total amount due is $955.95, and that would be through the month of June.
Bettina, what can you tell us about this?
Your Honor, the case manager is working with Mr. McCann to obtain all the documents so we can process his case.
Which will probably extend into July or maybe even August. The law requires that I set this for a second hearing 30 days away. Mr. Bradshaw, we're in an interesting period because the law was requiring us, Mr. Larkins, that may interest you as well, to set this second hearing 30 days away. That's from the directive from the Michigan Supreme Court, which was all fine while we were in the COVID stay period. Now all the landlords are gonna be into the next month. But in this case, it looks like there's a very strong possibility that Keystone's gonna provide emergency housing funding and we'll get back on track.
So what I contemplate will happen in this case, Your Honor, is one of two things. Either Keystone will just be cutting a check, or I will get with Mr. McCain and enter into some sort of conditional dismissal, which will contemplate payment probably the end of July, and which will include the month of July. Does that sound right, Ms. Emery? Do you think that by the end of July, this will be resolved?
Yes, I do.
Okay, so if I could get the defendant's contact information, Your Honor, or yeah, probably best that way. We'll get a conditional dismissal signed, including the month of July, payable at the end of the month of July, and we should be good to go.
All right, well, let's continue this. I'm missing some landlord tenant days in July because of my vacation. I'm
Sure.
going to continue this to July 26th at 1:15.
July 26th.
And hopefully we'll have something in front of you before then, and we won't have to have that date, take that date off.
I'm counting on that.
Okay.
Counting
And
on
if I,
Bettina to come through with the cash.
Oh, yeah.
and Mr. If I can get his phone number or contact information, that would be great.
Yeah, that would be 269.
Well, just a minute. I don't want you to really put it out over the feed.
Oh,
But
okay.
let's,
Okay.
call Mr. Bradshaw's office.
Let me give you my direct, and I don't mind this being on the feed. Mr. McCann, I'll give you my direct, and you could leave it on my voicemail if I'm in court, which I am now. And then I'll contact you. So you ready?
Yes.
It's 269
269
569
569
7590. And just leave your phone number. And if you could, leave your email address, and I'll get back with you and I'll prepare that paperwork I just discussed.
All right, perfect.
All right, thank you. I know you in a lot of places at once, Mr. Bradshaw. I'll let you go here. And we also had your manager here from Elm Tree. And thank you for that. So I'll remove it all. Mr. McCann, stay in contact with Keystone. You're going to be in contact with Mr. Bradshaw. We expect this to be paid and resolved, and hopefully you can get back to work. We just heard about a couple people that are well employed in the RV industry. They're all looking for help.
Yeah, I'm going to be getting back soon.
All right, you're good to go. Thank you.
All right. Thank you, Your Honor. Thanks for the patience.
Next time. Okay. And we'll remove manager Moto G7.
I have Julie still coming up
Oh, you've got another one?
right after. There was one set for 9:35 and the other one set for 9:45.
Who is the 945?
Julie McCann, his mother.
I wasn't aware of that.
Oh, it's what was sent to me from the lawyers, maybe. Maybe it was a typo.
We'll find out. It's not in my calendar.
Oh, then I'm not gonna worry about it. I'm good then.
No, I don't know what happened to Julie, but she's not set for today.
All right, that's great. Thank you.
All right, you can go. Thank you. All right, we're clicking up on 10 o'clock. Mr. Larkins is here with Miss Thornton. I'll remove mode G7.
I think you have to release me.
There you go. All right, this is Scott and Annette Larkins versus Sydney Bratcher. The file number is 21843LT. I don't know why I have this in here twice. This is a demand for termination of tenancy for a property at 186 East Michigan Avenue, apartment 2. What building is this, Mr. Larkins? I'm trying to figure out what 186 is.
Right in front of where you grew up.
Okay, that big house that was Dave Miller's?
Yes, sir.
Okay. Yeah, right in front of where I grew up. All right. This is filed, as I indicated, as a termination of tenancy. And the defendant was personally served. She is not here and is subject to default. The personal service was by Dick Meddy on June 2nd. When they don't appear, I have to set it for a second hearing 7 days away, at a minimum of 7 days away. It could be farther than that. When you have a termination of tenancy and they are personally served and they don't appear, they're subject to default. Are you going to ask for a default?
Yes, Your Honor.
Is she still there?
Yes, Your Honor.
All right. Default. Writ date is 6/28/21. I find by default the defendant was personally served and has failed to appear. Plaintiff has a right to recover possession of the property on or after June 28, which is 10 days from today. The appeal period is also June 28. What'll happen is they'll either show up in about 10 minutes or she'll get this and object, but they'll have 10 days to object. Otherwise, if they're not moved, you have the right to pursue the eviction. All right, while I have you here, I have your PPO request that I've been trying to decide on what to do with Miss Ewers. Miss Thornton, you can't get a PPO for everybody else. They'd have to petition on their own. Is this still problematic, or is this lady gone and
No,
Donna?
it's still ongoing. It was yesterday morning, we had the incident where she confronted me, and then yesterday afternoon at about 4, she was still continuing trying to contact me over phone, saying that she's going to be back to check her mailbox. So she's indicated that she will still be around.
Where is the mailbox here?
It's located on the side of the apartment building at 126 North Main, which is located across the street from my office.
Okay. What's on the ground floor of this building?
What's on the ground floor?
126. Well, I'm trying to figure out which building it is.
So it's our office is at next to Little Caesars.
The old Secretary of State office, Your Honor.
Okay. All right.
So across the street, it's a large red building next to Hot Rodders Inn.
Yeah, that's it's the old. Yeah. Okay.
I think it was a hotel or something back in the day.
Well, it was in the day, but it's Mr. Brundage's building.
Correct.
It was. Okay. All right. Okay. I'll review that later this morning. Thank you. Anything further regarding Ms. Brancher?
No, Your Honor.
All right. Thank you. Bettina, you had only really one hot case today. You've got to sit in on sort of a scrambled, a little bit disoriented damage hearing, but thank you for being with us. Mr. Larkins, I'll remove you from the feed.
Thank you, Your Honor.
Thank you.
Thank you. All right, Bettina, I guess I'll see you on Monday.
Sounds good.
More stuff. Let's keep getting people situated. All right, thank you.
Thank you.
Okay, I'm gonna stop the record for a moment. Finish this landlord tenant, and we will start again with general civil. And I'll bring in Rick Pattison, Efron Malavi, and Brandon Cruz. Good morning, Mr. Pattison.
Good morning, Your Honor.
Mr. Crew is here. Efren is here.
Excellent.
And I'm here, more or less.
That's good too.
And here we are. Mr. Crew, can you hear me?
Yeah, I can hear you.
All right. This is file 21508 GC. Rent-A-Center versus Brandon Crew. We'd spent some time with Mr. Crew on some other things. I did an order for possession pending judgment. This is the time and date for a hearing regarding, I guess, claim and delivery and request for a default. Mr. Pattison, what's the situation here?
We were able to recover after the last hearing. I believe it's 5 of the 8 items that were on rent. 3 we were not. So we are here to present evidence to the court to support a judgment which will basically consist of, we're asking the court to award us the things we were recovered. We'll ask the court to award us the fair market value of the things we could not recover, plus court costs and attorney fees, and the back rent associated with all the agreements. The back rent will present evidences will be on those items recovered will stop as of the recovery date of May 15th, and the other items, we'll say the rent stops today. So
all right, Mr. Crew, I want you to pay close attention. This can be kind of complicated, but there are formulas involved and some other things that they use in the rental owned business. I'm going to start by putting Mr. Efron Malavi, the store manager, under oath. Mr. Malavi, do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And your name is Efron Malavi?
Yes.
And you're the manager of the Rent-A-Center store in Sturgis. Is that correct?
Yes. Yes.
Mr. Pattison?
Just a little procedural thing. On your Brandon Cruz little box, I see half of what appears to be a couch or something, but no person. Is that intentional?
I don't know. I could see him earlier. Where are you, Mr. Crew?
I'm here.
All right. What are we looking at? Your ceiling?
Yeah. I was trying to keep my child from like screaming.
All right. Well, I'm just going to black your screen out. You've got an infant child there with you, but you've always been at every hearing.
Okay.
All right. Defendant's holding a very small, handsome child. Mr. Pattison?
Thank you, Your Honor. Mr. Malavi, as the manager of the store that's a plaintiff in this case, are you familiar with the business records involving Mr. Crew?
Yes.
And I have provided you extensive calculations pertaining to this case in support of a judgment, have I not?
Yes.
So when I go over this testimony with you, I want to make sure that what I say and what you say all we're on the same page. And if we aren't, please let me know, okay?
Yes.
So we've alleged in this complaint for claim and delivery that your store entered 7 rental purchase agreements with Mr. Crew, one dated May 22nd, 2020, 2 dated, 2020, and 2 dated September 14th, 2020, 1 dated September 21st, 2020, 1 dated November 21st, 2020, and another one dated November 23rd, 2020. Finally, one dated January 6th, 2021 for the merchandise we've listed in complaint. Is that true?
Yes.
We've said in the complaint that he stopped making payments. The last payment he received on any of the merchandise was on January 26, 2021. Is that true?
Yes.
And that the next due dates for payments on all these items was February 1st, 2021. Is that also true?
Yeah.
Yes? Your screen's frozen on me from my perspective.
Likewise.
Okay, back. Did you agree with my last statement about when the next due dates were?
Yes.
All right. Now, let's go through each and every one of these contracts in chronological order, please. The first one was for a Samsung 85-inch TV. That is something that you did recover on May 15, 2021. Is that correct?
Yes.
So you're asking the court in part to award you your rent that was past due from the next due date of 2/1/21 up until May 15, 2021, which is 14 weeks times the weekly rental rate in the agreement of $46.99 for back rent of $657.86. Is that right?
Yes.
Because we have recovered the property, we're not concerned about the fair market value. Agreed?
Yes.
Now, going to contract number 2, that involved an iPhone, and the contract was September 14, 2021. And again, 14 weeks, and that was returned, I should add on, May 15, 2021. So again, you're asking for rent for the same 14-week period. And when you multiply that by the weekly rental rate of $29.99, you come up with back rent of $419.18. Do you agree?
Yes.
And again, because we did recover it, we're not concerned about the fair market value. If we go on to agreement number 3, that's also dated September 14, 2020. That also is for an iPhone, and that has not been returned, correct?
That's correct.
So we have 19 weeks from the next due date up until today's date. You multiply that 19 weeks times the $29.99 per week, and your total back rent is $569.81. Is that right?
Yes.
Because we have not received the property back, you're seeking its fair market value, and we use a formula which recognizes the item depreciates over time. which is represented by the cash price minus the product of 0.45 times the number of weeks the contract's been in place times the weekly rental rate. And when we fill in those numbers here, we have a cash price of $1,871.54 minus the product of 0.45 times the 39 weeks the agreement's been in place times the weekly rental rate of $29.99. And when you subtract that product of $526.32 from the cash price, we come out with a fair market value of $1,345.21. Is that correct?
Yes.
Turning to
An expensive iPhone.
That's not even that much.
when we
All right.
proceed then. You have
Yes.
something, Judge?
No, I'm just dumbfounded at how much that is. Gonna be $2,000 for a phone he doesn't have. Well, go ahead. Number 4 contract.
That was the cash price, the 1,800 figure, yep. So going to contract number 4, we're talking about a Porter cable 20 volt max. Is that correct?
Yes.
Okay. Now what contract's dated on September 21st, 2020? I don't know. What is a Porter cable?
It's tools.
Ah, okay. Like a toolbox full of tools?
Yeah.
Okay.
These are power tools, I think.
Okay. Thank you. So that item was returned on May 15th, 2021. Is that correct?
Yes.
You're asking for the back rent that ran from the next due date of 2/1/21 through 5/15/21. So we had the same 14 weeks times $9.99 per week for total back rent of $139.86. Do you agree?
Yes.
Again, I hope you agree we don't need the fair market value because we're asking the court to award that property with the other to you as part of our judgment. Is that correct?
Yes.
Turning to contract number 5 dated November 21, 2020. That is for an 85-inch Samsung TV. Is that correct?
Yes.
And it was not returned. Is that correct?
That is correct.
Now, the back rent that's accumulated from the February 1st, 2021 next due date up through today's date is 19 weeks times the weekly rental rate of $29.99, which gives us total back rent of $569.81. Do you agree?
Yes.
When it comes to applying the depreciation formula to this agreement, we have a cash price of $1,945.33 less the product of 0.45 times the 28 weeks the contract's been in place times the weekly rental rate of $29.99, which does total $377.87. We subtract that $377.87 from the cash price of $1,945.33. The fair market value then comes out to $1,567.45. Is that correct?
Yes.
Bring the contract number 6.
All right, what was the fair market value there? I missed that.
It is $1,567.45.
All right, thank you.
Turning to contract, I'll call number 6. That is for a PlayStation and PSVR bundle. Is that correct?
Yes.
And was that returned on 5/15/21?
Yes.
Okay. So you're asking for the back rent pertaining to that, which we can calculate by multiplying that 14-week period times the $29.99 rental rate for a total rent of $419.86. Do you agree?
Yes.
Again, because we recovered the merchandise, we don't.
What was the rental rate per month on that?
$29.99.
Like everything. All right, thank you.
So we don't care about the fair market value because stuff has been recovered. Agreed?
Yes.
Going to number 7. We have a 3-piece slate Asiona Furniture Group.
Yeah.
That's the merchandise?
Yes.
And the contract is January 6, 2021. Now, that has not been recovered, true?
That is correct.
You're seeking both back rent and the fair market value of the property, which we calculate as follows. 19 weeks from the next due date to today's date, 19 times 39.99 equals 759.81. That's back rent. And when you apply the depreciation formula, using the cash price of $1,299.68, that the contracts have been in place 23 weeks and the weekly rental rate is $39.99, your fair market value calculation comes out to $885.78. Is that true?
Yes.
Now, if we go back and we calculate the back rent that's due on all 7 agreements that we've established, the total amount of back rent comes to $3,536.87, correct?
Yes.
And then when we add the 3 fair market values we've established today, the total fair market value of the property not recovered is $2,327.26. Is that correct?
Yes.
So if we start transferring some of these numbers to the proposed judgment, the amount of unpaid debt, which is back rent, is $3,536.87. The fair market value of the property not recovered is $2,327.26 for total damages of $5,864.13. Is that your understanding?
Yes.
You're also asking the court to award you your costs that you've had to incur in this case, which I understand is comprised of the filing fee of $150, a motion fee of $20, a subpoena fee of $6.50, and service of process fees of $63.52 for a total of $240.02. Is that right?
Yes.
You're asking the judge to award you the statutorily permitted attorney fee of $75 as well. Is that correct?
Yes.
When we add the 3 sums together, back rent, costs, and attorney fees, the total money judgment you're seeking is $6,179.15. Is that right, sir?
Yes.
So you are asking the court to check the box, well, the non-appearance to, well, he's here. So after trial or whatever, check the box above the numbers. We're asking the judge to check the box that awards you the property that's attached as page 2 of a proposed judgment. But we would ask the court to, on that list that's there, to cross out the 3 items that you were not able to recover, which would be item number 3, an Apple iPhone. Item number 5, one of the 85-inch Samsung TVs. And the 3-piece Asiona Slate furniture group. Is that right?
Yes.
Cross those out, and what's left is what the judge is awarding us because you've already picked it up, correct?
Yes.
May it please the court.
Mr. Crew, that's a lot. You've been ordered to pay back rent for all this property, back rent up to when it was recovered, and back rent up for today for the things that were not recovered, and then the fair market value of the things that were not recovered, which includes an iPhone, an 85-inch TV, and furniture. So the total is $6,179.15. 6,179.15 plus $240.20 plus $75 The total would be $6,494.35. They've taken sworn testimony under oath to establish both the back rent and the fair market value.
Roger,
The property was, I'm sorry?
little misunderstanding here on the numbers. Our
All right.
total damages is 5,800.
Oh, that's right. 5864. I wrote, and then I got the total.
The cost was $240.02, not 20 cents. Plus the $75 attorney fee for a total of $6,179.15.
All right, thank you. I had the 2 cents transposed, and then I double dipped on the cost. Yes, the damages are $3,536.87 for the total back rent for the 7 contracts, $2,327.26 for the fair market value of the property that was not recovered, an iPhone, an 85-inch television set, furniture. So the total damages that they're out as a result of this is $5,864.13. Mr. Crew, is there anything you wish to tell me?
Decline, decline, decline. For one, the couch they went there to get, they didn't get it. That's on their fault. He said it was destroyed because there was a scratch at the bottom of the couch. That doesn't make it destroyed. He didn't get it. The TV, they keep talking about this and that and that and this because the TV was broke. And I'm informed when I pay insurance at Rent Center, it should have been fixed. Me and Franco had a go about it, but when I signed a contract, I was informed if something was broken, that they would come back and fix it. Just like my refrigerator was broken that I bought there. No one ever came back and fixed it 8, 9, 10 months later. So decline. On top of that, this is what really irritates me at the most. How I'm one of the, I was one of the best customers there. I got over $20,000 invested there. And I like how people that's way past me can sit there and continue to pay on something that got months on months and months on top of me, but they immediately want my things back. Now, I found it a little bit of discrimination when I watch all these court videos about Rent-A-Center, how they extending everyone's time that's has more time than me and more stuff than me, but they want to come dig in my pockets and take all of my things because I had a minor setback. I just got my teeth pulled. That put me down. I was sick with strep throat. That put me down for a month. Franco should have already known all of these things because I wasn't leaving the house when he was telling me about these things, and I told them all of these things. On top of that, I just had a newborn. I had all these things. Then on top of that, my business was shut down this year because someone decided to steal my lawn equipment while I wasn't able to work. And all the prosecutor did was decline that position. They didn't even do anything about it. So in the midst of everyone knowing all of that, and they taking all of my things, not even giving me time to catch up or do anything, because this isn't the first time me and Franco had a fallout when I was set behind, and I caught it all back up as I was supposed to. So I'm declining everything. I'm not about to sit here and pay extra for things that's not worth it. I know what market value is. The TV is only $1,500. The phone is only $450. I know exactly what everything's worth. Couch is their fault because they was there. They should have got it. They didn't get it. So I'm not playing that game. The phone, I will pay for it because my responsibility, it was lost. The TV, I'm iffy on that because it was broken. The only reason I went to get another 85-inch TV is because it was broken. Even though my understanding is that me paying insurance for all of my items, it should have been fixed. And they told me they couldn't fix it. So what's the point of me paying for the insurance on everything that I had? So
all right, let me stop you. Let me stop you for a moment. I didn't put you under oath, so I will right now. You raise your right hand. You swear or affirm any testimony you're about to give or just gave was all true to the best of your knowledge and belief.
That's 100% truth. And I got my right hand up if you want to take the camera off.
All right, I believe you. All right, Mr. Malafi, what can you tell us about the insurance on the TV? He said he thought it was insured, and if it broke, it was.
Insurance on TVs only covers like anything that is like hand of God like incidents. The thing is that the TV was destroyed by someone else that because it wasn't with him. We can't cover neglect to any item.
What about the couch? He said you didn't recover the couch because it was scratched.
Well, we went back for it, but it wasn't there.
That's a lie.
All right. So it wasn't there to recover.
That's a lie. He showed me the pictures. They went there. They didn't recover it. They left. He has the pictures of it.
We did leave it the first time because, as I was told by my crew, that it was like not in good condition at all.
And it was a scratch.
All right. And then you went back to get it and it was gone?
Uh-huh. Well, also, I think the original people that lived there no longer live there.
They still live there.
They do?
Yeah.
Well, that's kind of vague. He says the couch was in good shape except for a scratch. You got some unnamed intermediaries in the middle, and what they told you is hearsay, but at some point they declined to recover the couch. Mr. Malone?
Yes.
All right. Brandon, what can you tell me about the couch?
The couch, and the couch was set there because I went to jail for some of my violations that I had. Besides all of that, like I went to Franco and I went to the office and complained why they didn't take the couch. This was in the middle of when they was telling me they was taking it to court. And he said the couch was in bad shape. The employee of his came over there with his phone and showed me the couch. It was just a scratch way at the bottom of the couch. It wasn't across the couch. It wasn't torn up. The couch was in good condition. There was no holes.
Where was the couch?
The couch was in Leonidas. That's where I was staying at the moment. But when I went to jail, I left there and told my probation officer because they stole my zero turn and sold it for some money. And like I told them, I sent them there to pick it up, told them the address. They went there to get it. They just looked at a scratch and said it wasn't like it was damaged, which it wasn't damaged. It was just a scratch. And that's the point with me. Like you went there to get it. His employees just too doggone lazy to get it because I done bought some stuff from Rent Center couch before that. And the whole back end was broken. I had to send that back to get that one.
All right. I'm gonna.
May I ask some questions, Your Honor?
Yes, you may.
Thank you. First, I'd like to ask some questions of Mr. Crew. Mr. Crew, do you know who Bruce Morse is?
Who?
Bruce Morse, Sergeant Bruce Morse.
Yes, I know who Bruce Morse is.
And you talked to Mr. Morse about this property?
About the property, I think.
Did you tell Mr. Morse that you had given the iPhone in question that's missing to some girl in Indiana?
No, the iPhone was told him about because
you didn't tell him that. You said gave it to a girl in Indiana.
I didn't say I gave it to anyone in Indiana. You're trying to question my you're trying to over question me. That's not what I said.
I'm having a hard time hearing. Did you tell Mr. Morse you gave the phone to a girl who lives in Indiana? So I can call him as a witness if you don't remember, but I'm asking you if you remember.
You're not listening.
Pardon me?
Well, this is a yes or no answer.
I showed
Stop. Mr. Morse isn't here. The iPhone isn't in dispute. The only thing in dispute is the couch. So
well, there's two other things here. I think there's two other. There's three items, and Mr. Morse and I had a conversation about what the defendant said happened to them, and which is a little bit different than the slant he's trying to sell you.
All right.
What plan? Because it's right there on text message.
I'm going to go to the second one. The
All right.
Samsung TV was broken, is that correct?
Yeah,
So
the
when
screen
Mr.
cracked
Morse
on the
went to
side.
pick up the stuff, why was it gone? Where was it?
He ain't went to go pick up the TV. That TV was broken way
Where
before
was the
this year.
TV when Mr. Morse came to execute the judge's order?
He didn't ask for the TV.
Did you tell Mr.
You don't.
Morse
You
the
got to go
TV
back.
was broken and was no longer with you?
No, the actual there was two TVs. You're
No,
understanding.
listen to my question. Things will go easier for you. One TV was broken.
I know how
You
to-
admitted that, correct?
The first TV was cracked on the side. They never came to pick it up, and the TV is still in my unit. So therefore, he told me he couldn't fix it. If I have to pay for insurance for everything, paying for insurance for everything that I buy, which means it should have been fixed. He told me it couldn't be broken, so it couldn't be fixed. That they couldn't cover it. So if they couldn't cover it, why am I paying insurance for something that you're telling me you can't fix? It comes with a liability. You can't over question me like I'm slow. I do own a business and I do run a business.
All right, let me stop everybody. I've lost complete control. People are just blasting out. He's not responding to your questions. I don't need the answers to these questions. You're entitled to ask them, but I've already got a find in your favor on those items. The only thing I'm concerned about right now is the couch.
I'll ask about that.
All right. Go ahead, Mr. Pattison.
I may have to ask Mr. Malavi more about this, but you're saying that Rent-A-Center came to pick up the couch on May 15th, is that correct?
Mr. Crew, are you still there?
Oh, you're talking about me? Yeah.
Yes, he's asking you about the couch, so go ahead and ask the question again.
Yes.
When Rent-A-Center came to pick up the other items, was the couch present?
There.
All right, I don't know if we're losing you or you're just not responding. I didn't turn the feed on because you're sitting there with an infant child in your
I
lap.
don't have my kid right now. He's laying down, so I can finish this.
Turn the video back on, then that may help. All right. Where was the couch there when Rent-A-Center came on May 15th to pick it up? Brandon, are you there?
Yes.
All right, well, can you answer the question?
Yes, the couch was there.
Well, the couch was
Yes,
there
I
on
said
May
yes
15th.
a couple times.
Oh, we didn't hear you. All
When
right.
they picked it up, yes, the couch was there.
On May 15th. Could you, I liked it
I
better
don't
with
know
the
what
picture
day
off.
it
You're
was.
making me dizzy. Could you sit in one spot, please? All right, so Mr. Pattis, I'm gonna let you try the question and we'll see how this goes.
Mr. Crew, have we established that when Rent-A-Center came by on May 15th, 2021, the couch, the three-piece set was at your home?
It was May 15th. I can't tell you the exact date, but I know they was there because they obviously got the pictures.
The
So I can
same
tell
day
you.
that he picked everything else up was the couch at your home?
Oh no, it wasn't at my home. They already knew where it was.
I'm asking, you're talking to me now, not them.
Oh,
Where
that's
was,
what I'm telling you. No, it wasn't there when they came to pick up the
where
TV.
was the couch?
I just said the couch was at the address.
What address?
That's on file in Leonidas, Michigan.
So it was in a different city than where you were living?
I just moved to that spot.
So why is it some of the stuff was in one spot and this couch is in?
Because I had to take it out of the unit.
Pardon me?
I had to take it out of the unit.
What unit?
When you move, you put things in a storage unit. Just like I have a lot of. What?
I never have. So why do
Well, that's you. Thank God to you that you're blessed and rich. You know, some people have to work harder for other things. So don't question my authority.
You're what?
my authority. Don't
You
question
have
what I'm
you have
doing.
no authority with me, just so you know that.
No,
You have no
stop.
authority with me.
Stop. This is going nowhere. All you're doing is fighting with each other. So I'm going to ask the questions. Stop. I get to wear this little black dress, so I get to direct the proceeding. You're not accomplishing anything except irritating him, and he's irritating you back. We're not getting anywhere. But anyway, Mr. Krug, so you had moved from Leonidas to Texas Avenue. Is that correct?
Yes, sir.
And at some point you put your stuff in a storage unit, which was news to us. So this couch at some point was in a storage unit. Is that correct?
The couch is still in Leonidas. I still have
All right.
residence in
Okay.
Leonidas.
All right. So when they came to Texas Avenue or the storage unit, where did they come to pick up the items that they picked up?
The rest of the items they came to pick up, which was the TV and the PlayStation, I believe, they picked it up at my house. The rest of the things I dropped off.
At Texas Avenue.
Yes, sir.
And the phone.
Yes,
All right,
sir.
and the phone. All right. So when they got to Texas Avenue, the couch was not there.
No.
It was in Leonidas.
Yeah, where they left it.
All right. What do you mean where they left it? Because they went to get it before. All right. Okay.
Yeah.
And they said it was scratched. Okay. All right.
May I say one more thing, please?
Yes, for the risk of going back down the rabbit hole.
No. But all this is moot. It's all moot for this reason. Whether it was damaged or not damaged, Rent-A-Center chose not to pick it up. And since they chose not to pick it up, then the defendant still he's using it in his home, and he's responsible to pay the rent that's accumulated. We've started this suit because he's in violation of the contract. So we're calling the contract in, saying it's over. So with regard to the couch, our argument is very simple. All right, you keep the couch, but you pay us the back rent that accumulated. You get to keep the couch and use it, but we want the fair market value of the couch if we're not getting it back. And that's consistent with what our damages are we presented to the court.
No, because I don't have the couch. You left the couch in Leonidas as I was moving. I informed him that I was moving, that he has to go get the couch. I already left Leonidas when they went to go pick up the couch. You left the couch, and now you think you're going to charge me for leaving a couch that was great, that was just scratched. That is on them. Then he said he went back, but I don't believe they went back for the couch. You just wanted to stick me in court and try to be God, He-Man, whatever you're trying to be, and you didn't get the couch. So therefore, when you had the chance to pick up the couch over a scratch, it's no longer my responsibility. I don't have the couch. You can come in my house. You can see I don't have the couch. They already came to my house. They can see that I don't have the couch because you left it there. Don't throw your dirt on me because you left the couch on there. They're employees. This is the thing. That is their job, is to pick up this couch. When they pick up the couch, if it's damaged, then they can come charge me for it. It wasn't damaged.
All right. The problem is, I don't know whether it was damaged or not. Neither does Mr. Malavi. Some witnesses who aren't here apparently said it was damaged. You said it was not damaged, at least not to the extent that they shouldn't have picked it up. Mr. Pattison argues that they decided not to take it and you should just have to keep it. This often happens with upholstered things like mattresses, chairs. I don't know whether it was damaged or not. They haven't proven that it was damaged. What he said was hearsay.
They have the picture.
All right. You say it wasn't damaged. And I'm not going to spend an hour and a half trying to figure out whether it was or it wasn't. So I'm splitting it in half. The damage for the couch was $885.78, and I'm splitting it in half. I'm reducing their judgment by $442.89. 586, 5,864.13 minus 442.89. $5,864.13 minus 442.89 equals, that's not right.
Franco has the picture of the couch. That's
All right.
what he's telling me.
I made a ruling. 5,421.24. You owe 5,442. 5,421.24 plus court costs of 240.02 plus an attorney fee of $75. It's $5,736.26. I will do an order to that effect. The one I've got is all messy, but I'll clean it up.
What's the
All
amount?
right. I'm sorry?
What was the amount? 576?
5736.26.
3626.
And 5,421.24.
Yeah, patience
All
to
right.
hear one more comment on this?
Excuse me?
Yeah, patience to hear one more comment on this?
Yes?
I'd had Mr. Malavi testify further. I'm sure you would have said, we would very much rather have our merchandise back so we can put it back on rent and make money again. If we left something behind, it was because it was beyond use for us to either repair and put back on rent, or wasn't in good condition to put back in rent as is. So that's just for future thinking.
Well, A, you didn't ask him that, and B, he never saw it. He didn't see it. What he knows is what somebody told him. And apparently there were pictures of it, which I didn't see, but the fact that it was damaged is hearsay as to him. So I don't know whether it was damaged or not. And I obviously know they would rather have the product back. So you have the burden of proof, and I found you didn't meet the burden, at least in regarding that, so I split it in half. So yes, thank you for your further comment. All right, that completes this record. I'm not going to try to set up a payment plan. Mr. Pattison will contact you regarding the very difficult process of trying to collect on this debt of $5,736.26. All right, you're all released and you can go on and have a good Friday, I guess. Thank you, Mr.
Have a good weekend.
All right, thanks.
Yeah.
All right. Okay, that finishes the civil portion of our docket. I'm going to stop the record. I do need to see someone from the jail. I'm going to stop the live feed.